My name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you for participating in this legal resource panel case law update. ECHO is a statewide nonprofit association devoted, excuse me, our mission is to foster a better quality of life in community associations through education, advocacy, and connection. For today's event, we have a few housekeeping rules that we'd like to go over with you. They are presented on the screen. We have a large number of attendees today, which usually means a lot of questions. We will do our best to answer them. Please use the Q&A icon, not the chat icon, to ask your questions and to make comments. You should use the chat icon to report any technical issues you may have and to communicate directly with other participants in the webinar. You will find these navigation icons by hovering over the bar at the bottom of your page. I will respond in writing to some questions in the Q&A feature during the presentation. Please keep your questions general in nature. Questions about specific situations are better asked one-on-one. To help us select the most relevant questions for this audience, please use the thumbs up icon found on the Q&A screen in the bottom left corner. Simply click this upvote icon to select your favorite questions. And now for our disclaimer, which you'll find on the screen. None of what is said during this seminar shall be construed as specific legal advice or expert advice from the speakers, sponsors, ECHO, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert. Thank you very much. Our webinar today is the Legal Resource Panel Case Law Update by Mark Walensky, Esquire. Mark serves as General Counsel to community associations for day-to-day activities, including the Davis-Sterling Act, interpreting governing documents, reviewing proposed contracts, and resolving owner disputes. He also works on claims for construction defects, budget shortfalls, and insurance coverage. Mark has focused on community associations since 1980, starting his own law firm in 1986. Mark, please take it away. Thank you.
Thank you, David, and thank you, Connor. Good afternoon, everyone, and welcome. My name is Mark Walensky. I am the chair of the ECHO Legal Resource Panel. Today, we are going to go over cases from the Courts of Appeal in California during the past 4 months since our last program. We're going to also then move to the trial courts for verdicts and settlements, particular interest to the Florida settlement in the condo collapse. Big news on several fronts. I assure you that although courts may seem like they are not functioning fully, the courts and the legislature in California are acting to make your life as a director and as an attorney more complicated. What can you do to break through the complications? The best you can do is to educate yourself for the developments. Thus, we have the educational community of homeowner associations. So a big virtual round of applause for David and Connor Zapponi and everyone at ECHO for keeping you informed. It's your best defense. We are working today from PowerPoint slides. Here's a summary of the cases and highlights of the verdicts and settlements. We're going to talk about unlicensed subcontractors. Unlicensed contractor of any kind in California is going to have a really tough time. You need to be informed. What about legal fees? It's frequent that homeowner association fights. The legal fees are more than the amount in controversy. How to protect yourself for recovering legal fees. What about settlement agreements? Many homeowner associations go to IDR or ADR, settle the case. When is a settlement a settlement? Well, one topic everyone wants to know about is short-term rentals, and particularly on the beach within the jurisdiction of the Coastal Commission. Coastal Commission approval of any changes are really important. The last appellate court case concerns the Rosenthal Fair Debt Collection Practice Act and restrictions on collecting amounts due. Your lifeblood is collecting your assessments to maintain your association. We will have good input from another attorney representing collectors, Tom Fear. Then we're going to move along to the trial courts and recent verdicts and settlements, including the condo collapse in Florida and recent developments and changes in Florida law. We're going to talk about insurance for claims in the millions and what kind of insurance you can get and when it's affordable, particularly regarding excess or umbrella coverage. And we will have guest speakers, Mr. Boland and Ms. Zimmerman will help us understand those topics. Next slide. Kim versus TWA Construction. This question is, what happens if your licensed general contractor uses an unlicensed subcontractor? Let's go over the general rules. It's real simple. Under Business and Professions Code 7031, if you do work that needs a contractor license and you do not have a license, two things happen. You must give back every penny that you've been paid, and you cannot sue in court to collect any amounts you claim due. Let's see what happened in Kim. Kim involves a unique situation where the owner's general contractor is licensed, but a subcontractor is not. Can the licensed general contractor collect for that work? No, not according to the Kim case. So what happened? Owners of a home in Los Gatos hired TWA Construction, a licensed contractor, to build out the home. TWA hires Hoffman, an unlicensed subcontractor, to remove a 150-foot tall eucalyptus tree, 6 feet wide, crossing the lot line of the neighbor. Neighbor claims tree damage for property he owns, sues owner. Owner cross complains against TWA, saying you hired an unlicensed tree remover. What does the tree remover, Hoffman, say about this? Nowhere to be found. Didn't participate in the case. They're just gone with the wind. TWA cannot prove that its tree sub Hoffman had a necessary tree service license. Jury verdict, TWA general contractor license is liable for all tree damage. Owners paid $10,000 to TWA for work by its unlicensed subcontractor. Trial court, judgment for owners. TWA must repay the $10,000 the owners paid for the subcontractor work when that subcontractor was unlicensed, plus contractual owners' legal fees and expert fees. Court of Appeal, affirm. An unlicensed subcontractor cannot recover from the general or from the owners. Therefore, as a matter of public policy, the Court of Appeal held the general cannot recover from the owner for unlicensed subcontractor work. One question remains. The Court of Appeal opinion did not get to it because it was not briefed properly. The question is an unlicensed subcontractor deemed by law to be an employee of the licensed general? That argument was not made. Maybe that was a mistake, who knows? But there is a possibility that an unlicensed subcontractor could be a deemed employee, in which case licensure would be effective. Next slide. How do you know if a contractor is licensed? You might say, Mark, we can't possibly know all these subcontractors and everybody involved with our construction work. I say to you, it's simple. It'll take you 2 minutes. You saw this slide at our last presentation. I'm doing it again for emphasis. All you have to do is search the Contractor State License Board website, www.cslb.ca.gov. The first home slide that pops up is check a license. Click on that. Here's what you get right in the middle of the page. Click on the license number and put in the license number. Click on the business name and put in the business name. That will tell you whether the contractor is licensed, whether that license is active or suspended. It will tell you a variety of other things, what kind of license it has, who are the principals by name, and it'll tell you whether the contractor has workers' compensation, critical workers' compensation. You will see how important that is in a minute. If the contractor claims no employees and is exempt from workers' comp and drives up in a van with 6 people that jump out and unload shovels, you know you got a problem. Ask the contractor for a certificate of workers' comp. It's easy. Next slide. Artis versus Gramercy Towers. Artis is an owner at Gramercy Towers. 3 units. There have been at least 3 prior lawsuits reported in this Court of Appeals opinion. In this particular suit, the owner sued the association for declaratory relief and injunctions. How much money did the owner want? Declaratory relief and injunctions regarding election rules and voting rules and sale and leasing guidelines that had been adopted by the HOA. The HOA wins the trial court, demurrer and anti-SLAPP, various procedures to cut down the claims. Claims are cut down. Association gives a little and changes some of the rules. Suit is then found moot. Nothing to fight about in court. They've agreed to everything, or they've been thrown out. Both sides claim attorney's fees over $300,000. The court online docket, register of actions, 32 pages long. The motion for attorney's fees, 1,800 pages of points and authorities, declarations, and exhibits. The trial court says neither side prevailed. The owner, the plaintiff, achieved one of 4 litigation objectives and did not provide a significant benefit to the general public as defined under Code of Civil Procedure 10215. What about the homeowner association? Didn't it win? The association acted unilaterally to resolve this thing without court order, but it forced the court action before that unilateral action took place. Therefore, the court did not award plaintiff prevailing party. Court did not award the association as prevailing over the owner because it acted unilaterally. Court of Appeal affirmed no prevailing party. In San Francisco, Judge Kahn held a lengthy hearing and issued a 20-page order. The main fight in the Court of Appeal was the standard of review. Well, what does that mean? The plaintiff wanted the Court of Appeal to substitute as the trial court and start from the beginning and weigh everything, who won, who one of 4 objectives. This Court of Appeal said, we're not doing that. We only look for abuse of discretion, not de novo. De novo, we start over again like the trial court. The review is abuse of discretion. The test is whether the trial court ruling is an abuse of discretion. Is it so irrational or arbitrary that no reasonable person could agree? If so, it's an abuse of discretion. But that wasn't here. That wasn't Judge Kahn. 20 pages, all kinds of authority, horribly difficult case. Don't run to court, run to try to work things out. Next slide. Fettig versus Hilton Gardens. When is a settlement agreement a contract that is enforceable? Plaintiff claims to be hit by a shuttle bus from a Hilton's Garden Inn. Hilton Gardens Inn says it never happened. Plaintiff rests at trial, and Hilton offers $85,000 to settle the case in the middle of trial. Lengthy hearing by the court, 2 recesses, plaintiff to confer with attorney. Plaintiff agrees to settle for $85,000, except a few months later, plaintiff changes her mind. New lawyers and move to set aside the settlement for duress of the plaintiff's attorney, who said, unless you take the $85,000, I'm not coming back to court tomorrow. The court is asked to rescind the settlement. Trial court hearing showed plaintiff had the capacity to settle. Plaintiff was not so injured that they did not understand the proceeding. No way. Understood everything, met with the lawyer, and agreed to the settlement. This thing about I'm not coming back to court tomorrow was never conveyed to the defendant. The defendant did not know of the alleged duress or threat, relied on good faith, and surrendered the possibility of a defense verdict. That's all it takes. Court of Appeals says the case had serious problems. For example, lost income, very little. Medical bills, none. $85,000, Court of Appeals says we're affirming that. Next slide. Keynes versus City of Manhattan Beach. Another case, seems like we have one every quarter. Short-term rentals in a beach community governed by the Coastal Commission. The Coastal Act of 1976 established the Coastal Commission with a job to protect the coast and maximize public access. Liberal construction in the courts to those ends. Coastal governments are, like Manhattan Beach, are required to have a coastal program. And if it meets the act, the commission, the Coastal Commission, will certify it. Then it's valid. Here, Manhattan Beach developed a coastal program, and it was approved by the Coastal Commission in 1994. It allowed rentals of apartments and homes, no distinction about short-term or long-term. 2015, it's a long time, 94 to 15. City of Manhattan Beach proposes two ordinances allegedly restating a pre-existing ban on short-term rentals, which the court concluded never existed. The pre-existing ban never existed. Coastal Commission suggests that in pursuant to the act, they should allow some form of short-term renting. City withdraws its request to the Coastal Commission for the 2015 ordinances. 2019, city adopts more ordinances requiring platforms like Airbnb to report certain things to the city. Meanwhile, plaintiff Keene is cited for violations of the act. The 15 and 19 ordinances. Trial court, plaintiff wins. The 94 ordinance was certified by the Coastal Commission, but the 15 and 19 amendments required commission approval and never got it. Therefore, 15 and 19, whatever the city did, is void. Court of Appeal, affirm. Coastal programs by governments like the city of Manhattan Beach can be amended, but only after commission approval. The alleged ban on short-term rentals would be an amendment requiring approval, but the Coastal Commission never approved. So it all refers back to the 94 ordinance, which was silent about short-term rentals, generally allowing rentals of every nature. Back to the drawing board for City of Manhattan Beach. Next slide. People versus Alorica. People, wait a minute, Mark, that's a criminal thing. What are you doing talking about criminal stuff in this? We are. The people are several district attorneys' offices that band together and tried to get records, subpoenas from Alorica Inc. to decide whether Alorica complies with the Fair Debt Collection Practices Act. The investigative subpoenas were served on Alorica 2015 to 2019, 11 document requests about Alorica's collection services and whether it complied with the Debt Collection Practices Act. Alorica says, hey, we don't collect debts, so you can't subpoena us. Trial court, wrong. District attorney has authority to determine whether or not there's been compliance with the Rosenthal Fair Debt Collection Practices Act. And they have investigative powers, including authority to issue record subpoenas to tell whether the act is met. Let me tell you one thing that is certain as the sun rises every morning. You do not want to have the government coming after you. Unlimited money, unlimited resources. You might say, hey, Mark, we have insurance. Oh yeah? Is there insurance from a district attorney's subpoena, you might have another fight on your hands. The trial court allows the DAs to get Alorica's records, and it appeals. The appeals court says Alorica has got to turn over those records to show whether it is subject to the Fair Debt Collection Practices Act. The people have investigative powers, including the authority to issue record subpoenas. I'll tell you, Alorica spending a lot of money to try to avoid this. Fortunately, we have an attorney with us today who represents debt collectors and knows more about this. And I would request some comments from Tom Fear. Tom, take it away.
Thanks, Mark. There we go, next slide. So the important thing to remember about this case is that obviously the DA has a lot of investigative powers, and Alorica is involved, has its hands and fingers out in a lot of stuff. One of them basically was to collect debts from their clients. DA got upset. And by the way, these coordinated actions amongst various county DAs is a result of the Pro Solutions case that went through the court system a couple of years ago. And as a result of that, all of a sudden the DAs, like they don't have enough to do, they start looking, and each DA has kind of a civil arm where people can complain. And obviously when a homeowner is delinquent in their assessments, and the HOA, either the HOA or whoever they've hired to collect their delinquent assessments, comes after these people are desperate, they complain the DA. And generally, within the past couple of years, there have been a number of counties that coordinate investigative actions and go after people. And it's not really, from an HOA standpoint, and whoever you choose, whatever entity it is to collect your delinquent assessments, make sure that they're up and up, that whatever contract or agreement they have with you says that they're going to comply with all federal, state, and local regulations. And if the DA comes after them, don't fight it. They're going to get their information anyway. As Mark said, they're more powerful than an HOA or any other entity. They're going to come after you and they're going to win. So I guess the lesson to be learned here is that, yes, DAs are looking out or looking after debt collectors who go after people for delinquent assessments. Word to the wise, just make sure you have everything up and up, and that you are complying with all the state Rosenthal Fair Debt Collection Practices Act, the federal companion to that, and any other internal documents that you have. Make sure you comply with all that. And hopefully there won't be somebody out there who complains, who leads the DA to start investigating. Okay, Mark also asked me just to give some brief comments on debt collection, which we kind of went over a little bit the last time, but I just want to reinforce some of that. There is this debt collection licensing law, okay? Up there on your slide is Civil Code sections 1788.11 and 1788.52. There's also some financial codes included in this, but basically, as of the first of the year, debt collectors have to be licensed. And they had to apply before the end of the year. Okay, problem arises. They have to do a background check on everybody who applies. And the FBI has to do it because this debt collection licensing law goes into a registry that's national. And what happens is the FBI investigates background checks on all these people. Well, that's caused delays. And the courts, or not the courts, but the the agency that has jurisdiction over the Licensing Act, the Department of Oversight, they have said that debt collectors can continue to do business while their application is pending. So from an HOA standpoint, is an HOA subject to getting a debt collector's license? The answer is no. The next question is, are attorneys subject to this licensing? That's up in the air, okay? And it depends on how much your practice is devoted to collecting delinquent assessments, okay? And usually the guideline for this comes from federal cases that have to do with the Federal Fair Debt Collection Practices Act. They're the only ones that have had cases that have dealt with whether or not an attorney is subject to it, okay? Those cases, there have been two. One says that if 1.4% of your practice is devoted to debt collection, this is an attorney or a law firm, you're not considered to be a debt collector. However, if 4% of your practice concerns debt collecting, you are subject to both federal and state law. So word of the wise here is that as an attorney, there are certain notices. If you're going after somebody's, ABC homeowner association has contacted you and says, hey, somebody owes us $3,000. We'd like you to go collect the money. So in your communications to the delinquent homeowner, make sure that you have what's called the mini Miranda warning at the bottom, or the disclaimer that gives certain information both under federal and state standards, and make sure that you comply with that, because I've seen cases where attorneys have not, it's not in the correct type size. It has missed a wording. It's summarized what's supposed to be there. And there are these law firms that go around and say, hey, by the way, you violated this. We want X amount of dollars to settle. And some entities fight it, and they wind up spending a fortune and wind up paying them anyway. Or they just cave in and say, okay, we blew it. We learned our lesson. It's an education. Let's move on. So, Mark, I think that's it. You wanted me to be brief? I think I've been brief.
So don't even think about collecting a debt yourself. It is so complicated with state and federal rules, licensing, type size, required language. Use a professional debt collector. Next slide. We are now in the trial court. And of course, the trial court du jour is in Surfside, Florida. $997 million. That's not a typo. $1 billion for the condo collapse in Surfside, Florida. 136 units, 40-year-old building, 98 people dead. 98 people, 997 million, 10 million per person. And that's just the wrongful death claims. In addition, the settlement is from another 83 million for property damage, plus 100 million from sale of the land. That's an empty lot now that are going to be redeveloped. In addition, Oh, who paid? The settlement summary is a little bit vague on the payment. I think there was some confidential settlement, but in general, it was the insurers and the engineers and others. There was a big issue about whether or not the next door neighbor property destabilized the foundation. Subsurface destabilization. That was never resolved in the summary, but the claim was made. What caused the collapse? The cause has not been fully determined. The investigation is ongoing. There are alleged defects in design, original design, defects in original construction, defects in maintenance over time. What is known is there was a swimming pool in a post-tension slab that leaked. So the slab may have damaged the post-tensioning cables. There's the neighbor building subsurface collapse allegation, lack of support alleged. Like California, the laws in Florida did not mandate collecting reserves. In California, you must do reserve studies, then it's disclosure, how much has been funded. Actually collecting reserves was not required. That changed. As of May 25, 2022, in Florida, the legislature passed SB 4D. Condominium buildings 3 stories or more within 3 miles of the beach, 25-year required review on structure, and then every 10 years. Buildings more than 3 miles, the first 30 years, and then every 10 years. Inspection records required by law from those inspections made available to the public. And here is the kicker. Associations are prohibited from waiving collecting reserve funds. So associations must collect reserves to preserve the building after 25 or 30 years, depending where they're located. This has had a predictable effect since assessments must be levied now, or at least after December 31 of 2024. Prices of affected condominium buildings in Florida, year over year, minus 60% loss in value. Whereas buildings not subject to this mandatory reporting and reserves and single-family homes have skyrocketed. Property in general, skyrocketed. So is this coming to California? California legislature seems to have never met a HOA restriction that it doesn't like. So your guess is as good as mine, but it's likely that these things will come to pass for mandatory reserves in certain areas. Let's talk about the bottom line on that bubble, condo termination. What does that mean? It's happening in Florida, could happen here too. A developer buys all the units. CC&Rs generally talk about condo termination. What does it take to terminate the condominium and demolish the building to the dirt? Follow that procedure in the CC&Rs, and you have a condo termination. All the buyers are paid off, and the building is demolished, sold to a developer, and rebuilt. What percentage does it take? Read the CC&Rs. It varies. Litigation for years about whether you have the right percentage? Could be. This is tied to the mandatory large assessments for reserves that cannot be waived. It could be coming to California. It is in Florida. Right-hand bubble, 12.2 million, jury verdict. Not a settlement, jury verdict. Jessica Vu versus 2447 Pacific Coast Highway. This is a commercial office building. Property manager had the carpet cleaned. Hey, you got to clean the carpet. The carpet was allegedly wet. Plaintiff slipped and fell down a flight of stairs. Allegedly epoxy flooring with anti-slip additives defects. Failure to warn of the wet carpet and the anti-slip defects. Defense says, hey, this carpet was dry. The plaintiff simply missed the first step and fell down the flight of stairs. We have two witnesses. Alleged traumatic brain injury. Defense says pre-existing from history of depression, anxiety. Jury verdict, $12 million for a head injury, lots of lost wages. Of this amount, 10 million was past and future pain and suffering. 10 of 12 million. 1.8 million lost income, lost earnings. 418,000 future medical. There you have it. Does your carpet cleaner have $12 million of insurance? Do you? We'll talk about excess policies. Next slide. 6,300,000 Pennington versus Tetra Tech and Lennar Corp and many others. This is Hunters Point U.S. Navy shipyard in San Francisco, 500 acres. Navy used nuclear materials in ship repair and decontamination. The shipyard was shut in 74. EPA Superfund in 89. San Francisco redevelopment plan in 97 for mixed use residential, commercial, and light industrial. The allegations are that Tetra Tech falsified certain soil sampling data and other misconduct in the cleanup and failed to disclose it. This settlement occurred between the plaintiffs, homeowners, and Lennar and Five Point, who said they disclosed everything they knew. It was opposed by Tetra Tech. The court entered confirmation of the settlement with Lennar and Five Point. Tetra Tech denies wrongdoing, and the case continues. The plaintiff's lawyer is Joe Cachet, a very well-known plaintiff's lawyer from the peninsula. Right side bubble, $3,400,000. This was a very brief report of a settlement. They didn't even name the parties. John Doe versus Rowe Recreational Facility in Sonoma, Superior. The plaintiff was using playground swings. Nothing about the plaintiff's age, weight, education, marital status, nothing. Just that the plaintiff was using the playground swings at a, quote, recreational facility, and a middle link tore through a plastic seat Plaintiff was on an upswing and kept going. Fell in a rocky creek bed. Plaintiff says wrong seats, no use zone surface, little wood chips missing, failure to inspect and maintain. Defendant says, you saw the swing set before you get on it. You assume the risk. Orthopedic injuries to vertebra, ribs, elbow, and wrist, hospital 11 days. You have 3.4 million in liability insurance for your swing set. Next slide. 2.3 million, Bulos, Herrera versus Bulos. Plaintiff injured when doing tree trimming work. Ladder is a single family residence and the ladder slips and plaintiff falls 15 feet to the concrete. No contractor license. Residential home in Fullerton. Defendant provided the ladder, the homeowner provided the ladder. It was missing a base grip. Of course, the plaintiff alleged he should have been trained in use of the ladder and that the owner provided no training. Alleged traumatic brain injury, fractured ribs, pulmonary, cervical, and lumbar spine problems. No mention of deemed employee, no mention of workers' comp. Did this homeowner act as a deemed employer? Not mentioned in the settlement. Did the homeowner have workers' comp? Not mentioned. Would workers' comp have applied? Not mentioned. Right-hand side. $500,000 settlement, policy limits. What that means is it might have gone for even more. Virginia Green versus Minnesee Lou, Los Angeles Superior, settlement. Plaintiff is a 74-year-old retired nurse attacked by her driveway by a neighbor's dog. $500,000 for a dog bite? There's no mention of a bite, only the fall. It could be that the plaintiff was simply knocked over. Plaintiff says broke her hip and fractured elbow, hospital surgeries, and the dog bite statute. And the dog statute is real simple. Your dog injures, you pay. That's it. Whether it's a bite or a fall. No mention of any homeowner association in this case. Here's something homeowner associations might consider. Do you have CC&Rs that limit weights or dog breed restrictions? Yeah, you let them have a dog, but not that weight or not that breed. I guarantee you that if a breed causes injury, they're going to do a blood test to that breed to see if it's a restricted breed. If associations have limits on the types of dogs that can be allowed, and those limits are violated, pull out the checkbook. Next slide. We're going to talk about 3 slides now before we talk about excess or umbrella coverage. Each is about 20 million. Don't forget, in the Surfside case, the wrongful death was about 10 million each for the 98 plaintiffs. Here, this is 24 million. And only one of the 3 involves a death. If you've got a lifetime 24/7 attendant care, you're going to pay more. Left bubble. Felipe Leon versus Union Pacific Railroad. Plaintiff is driving a motorcycle at age 30. No mention of employment or education or marital status, no mention. Plaintiff says, you hit me while I was on my motorcycle and now I have traumatic brain injury, facial facial and hip fractures, 24/7 attendant care. Whatever he did before, he's unemployable from it now. This is what a jury says a 30-year-old plaintiff is worth when he becomes disabled, totally disabled. Look at the right bubble. Jane Doe versus City of Long Beach. Minor is crossing a busy street at night. Minor gets hit by a car. Sues the City of Long Beach to get 23 million. Who has 23 million in coverage? You got to sue something like a government entity like a Long Beach or a government substitute like a homeowner association. Well, this didn't involve a homeowner association, but it claimed, the plaintiff claimed, they needed a flashing beacon because of heavy traffic and known speeding violations in the area. Defendant says, hey, we have extensive signage, no accident history. We have design immunity in the City of Long Beach. And the other driver caused it, not me. Plaintiff says traumatic brain injury, obviously 24/7 attendant care is possible. Defendant says pre-existing developmental delays. Settlement. You've got two sophisticated attorneys agreeing, two sides agreeing to settle this case for 23 million. Last slide on trial court verdicts and settlements. $19 million. Plaintiff's dead. Carol Cardona is for the estate of deceased Monique Munoz. This is a story about defendant James Corey gifting his son Brendan for his 17th birthday a Lamborghini Urus SUV to drive around Beverly Hills. Plaintiff, age 32, coming home from work at UCLA Health. No indication in this brief summary what plaintiff did. Was plaintiff a doctor? Was plaintiff sweeping the floors? No idea from the settlement summary. Defendant makes the 17-year-old makes a left turn and the defendant makes a left turn and the plaintiff makes a left turn. As the plaintiff is doing so, the defendant runs a red light at allegedly 100 miles an hour in a 35-mile zone. 17-year-old defendant pleads guilty to felony fatal crash. Life value of a 32-year-old woman, $19 million. You might say, Mark, what does this have to do with a homeowner association? This is crazy. The answer is, do you have a homeowner association that poses threats to life safety? How about a swimming pool? How about large trees with branches that might fall off? How about roads that you maintain? How about recreational facilities with a swing set? Since these three settlement bubbles are about $20 million for the death of a 32-year-old and a life threatening injury for a 6-year-old, should your association carry $20 million in liability insurance? Should you carry 10 million? How do you decide? How much does it cost if you buy an excess policy? for $20 million. These, I don't care what you call it. You can call it jury inflation. Verdicts are coming in at $20 million for these kind of injuries. Fortunately, we have someone today who can help us understand more about availability of large insurance policies like this. And it's up to you to determine what your facilities threaten and whether you should have this kind of insurance. So I'd like to turn the program over to Kevin Boland, a farmer's agent, and ask him to address some of these issues for you. Thank you, Kevin.
Hi, everyone. My name is Kevin Boland, Farmers Insurance Agent based out of Novato, California. Thank you, Mark, for all that information today. I'm always surprised at how high the verdicts are becoming in the last couple of years. And one of the ways that homeowner associations, and one of the reasons I was asked to talk today, one of the ways that homeowner associations can protect yourself against these large lawsuits is by purchasing an umbrella policy. And there are two types of umbrella policies. One is called an excess umbrella, and one is called a standard or regular umbrella policy. I want to make sure you understand the difference between both. So please take out your pen and notepad and take some notes. Okay, next slide, Connor. Thank you. So an excess umbrella policy will give you more dollar amount of coverage over and above your underlying general liability policy, your directors and officers insurance policy, and your workers' compensation insurance policy. So all those risks that you're typically covered with your regular insurance, the excess umbrella policy will insure you with more dollars. And you can typically go from 1 to 5, 10, 25 to $50 million. Although, after listening to Mark today and hearing about the large settlements and the increase in litigation costs, that those higher umbrella limits are getting much harder to obtain. And you're going to see typically the umbrella policies in the last year going up by either doubling or tripling in annual premium. So the excess umbrella policy also has no SIR or deductible. Sorry about that. An SIR is insurance speak. It means self-insured retention, very similar to a deductible. But one little clue that if you have an excess umbrella policy, you want to look to see if there's a deductible. If you don't have a deductible, that may mean that you're limited in coverage to only be insured for those same underlying coverages. So if I can get to the next slide, Connor. So the excess umbrella policy covers only those risks that are going to be covered with your underlying policies. A regular umbrella can offer you broader coverage, and that could be an important thing to have. One example would be, let's say your general liability policy doesn't cover libel or slander or defamation of character, and a homeowner finds out that the board was talking about him or her in a meeting, and there may be just some documentation or some people at the homeowners forum that could be subpoenaed and testify on that behalf. So now you've got a libel, slander, or a defamation of character on your claim on your hand. And if you have a regular umbrella policy, you'll typically have coverage for that type of lawsuit. And like I always say to my clients, you know, these types of large lawsuits, they are rare, but when they happen, they're like an earthquake. They're devastating, and they can financially ruin, you know, the reserves as well as the operating account in our associations. I'm a board president of my association too, so I realize the risks that are involved. So once again, the regular umbrella policy, it's a little broader, it's a little better. I recommend you get that versus an excess policy. One little clue to know whether or not you currently have an excess or a standard umbrella policy is to look to see if you have a SIR or self-insured retention or deductible. If you don't have it, you probably just have the basic excess policy. If you do have it, that means you have broader coverage, typically in your umbrella policy. Okay, next slide, Connor. So I was asked to talk about the availability today of umbrellas. Yes, they still are available, but as I mentioned earlier, you're going to probably pay double or triple for associations. A lot of the reasons that Mark's already spelled out for us clearly: more litigation, high rewards, There's a big problem today with Zisco panels. If you have an association, you have Zisco panels, they're considered higher risk than average electrical panels. Now, a lot of insurance carriers today are either non-renewing an association that has those, or they are raising the rates. Let's see here. So what are the costs for an umbrella policy? Well, my company, Farmers, we can go up to $10 million, and that's going to cost you about $5,500 a year. In the past, I used to write Farmers for the master policy, and I go to a good friend of mine named David Crowley, a good agent up in the Santa Rosa area, and he would get for me a lot of great umbrella policies. I could get a $25 million umbrella policy for $2,000. Amazing. That's all changed. Like as Mark was telling us, it's a whole new game now. So if you want to get a $5, $10, or $50 million umbrella policy, you can still get it, but you're going to pay for it. Some insurance carriers, which you really shouldn't need to worry about, your insurance broker can probably identify these carriers for you, but Great American was the insurance umbrella carrier, I understand, for the condominium collapse at Surfside. So they just, guess what? They're out of the market. They no longer offer umbrellas to associations. I guess they were a bit underfunded. Amwins is a good insurance company. They can come up with a $20 million umbrella for you. Cirrus Point Specialty Insurance Company, SIRIUS, Cirrus Point, they can give an umbrella up to $5 million. And let's see, and then there's a new carrier, a new program I just heard about from Greenwich Insurance Company. They haven't come out with it yet, but they're saying they're going to really offer some better pricing and some pretty good coverages as well. So keep your eye on for that. And one of the things you can also do, let's say you're a big association, you have 400 or 500 homes, and you really want to get a $20 million umbrella. You can look to your primary carrier, like Farmers in my example, we can go up to 10 million, and then you can go outside and get another excess or a regular umbrella policy on top of that. So there's another solution where you can get your 20 million. And I won't talk more about big cases because Mark did a great job for us today, but I will tell you my own personal experience here in Northern California. 2 years ago, we had a young gal drown in a pool, and it was a little baby party, 8 years old. Nobody paid attention to one of the kids in the pool. They were doing helium, when you suck in that helium to make your voice sound funny. Well, nobody found her for 9 minutes. And there's actually, well, I won't go into more detail, but the poor kid fell in. Nobody discovered it for 9 minutes. So you better believe that's going to be a huge lawsuit. I just had a trip and fall. I got a picture emailed to me Monday from somebody in a hospital bed, said that they tripped and fell on the asphalt on a sidewalk for a homeowner association. And in addition to that picture, they had a picture of a measuring tape showing that the crack, the difference in level between the two sidewalks was over 1 inch. That's terrible. The California building codes want you to shave down anything that's 1/4 of an inch high or higher. So there's another big lawsuit that's about to occur. Also, a couple of years ago, we had a person who was in a hammock, a young child. They got caught up in the hammock and they suffered brain damage. It was they were oxygen deprived. So if you have a hammock in your association, I recommend you take it down. Anyway, just some quick examples there of what you have to be worried about. So next slide, please, Connor. Thank you. So my key takeaways are Kevin's tips today. So when you purchase an umbrella policy, make sure that you ask your insurance broker, will this cover on top of our directors and officers insurance policy? Because believe it or not, some don't. There's an exclusion in there. And if you have a major D&O policy, it can go on for years and cost you millions of dollars. So you want to make sure your umbrella policy covers that. Secondly, make sure that your umbrella policy covers what's called EPLI, Employers Practices Liability Insurance. So if you have a part-time handy person, or if you're a large HOA with a lot of employees, make sure your umbrella policy will cover lawsuits of EPLI, because some don't. And then also make sure you report your claims quickly. We just had a case a few months ago where there was a sexual harassment claim. An email was sent by the employee claiming sexual harassment by a manager. And this particular company decided they would handle it on their own. Big mistake. The plaintiff's attorney asked for a lot more money at the end, and they decided to turn it over to our insurance company. Guess what? It was too late. In every insurance policy for general liability, there's something called a condition. And the condition is you better notify us promptly so we can put together a great defense. And they didn't do that for over a year, so now they're on their own. And my last point is confirm your defense costs, your attorney fees are in excess of your settlement amount, of your limit. That's very important too. My job, as I see it, is encourage all of our board members out there, myself included, make sure we ask smart questions of our insurance broker or your manager. And that way you can make sure you're properly insured. So I think that's it for me today. I just wanted to talk about the umbrella policy. It is available, but expect to pay more in your budgets. So I think that's it for me. Thank you, everyone, for listening today.
Maybe you might say, Mark, I don't care about insurance. We don't own any property at our HOA. It's all jointly owned. There's nothing to take. I want to say that I have seen cases where courts order an assessment to meet a judgment. Let me say that again. Courts order an assessment against your owners to meet a judgment. Umbrella insurance, you just heard Kevin tell you, is incredibly cheap. It's a board decision how much to buy. I'm giving you the numbers where verdicts are coming in. You might say, oh, that's just a runaway jury. But we'd include settlements that knowledgeable attorneys agree. The decision is up to you. I'd like to change now and ask for some comments by attorney Barbara Zimmerman. Barbara Zimmerman practices in Sonoma County. In addition to wonderful wine, Sonoma County has been known for recently fires. And normal insurance inflation in general has every premiums going up, especially when there's wildfires like now. What is going on with fire insurance and what can associations do? I'm asking Barbara to fill us in. Help us understand this, Barbara. Thank you.
You're welcome. So yes, everybody's seeing a lot of premium increases in their insurance. Pretty much all of my HOAs across the board, whether they're in a fire zone or not, are seeing the increases. The primary reasons that we're hearing for the increases from the insurance companies are the age of the developments. Even before the Chaplain Towers collapse, we were seeing price increases just due to the risk of more claims in older buildings. Even your smaller claims like aging appliances and water lines and plumbing fixtures, those start adding up as the buildings get older. So we were seeing price increases for those. Claims history seems to be one cited frequently now, but mostly with very large claims, associations that have large litigations that the insurance companies are covering, that has had multiple substantial claims for fires that are not wildfire or for water leaks. And of course, wildfire risk. Based on wherever you fall on the California map for fire risk, will determine a lot as to whether you can get coverage even, and what kind of coverage you can get. Here in Sonoma County, we've had a lot of associations who have gotten non-renewals because of their fire location. So next slide. What can associations do to lessen the burden of these increases? And there's a couple of options. One is to amend your CC&Rs to either require the owners, well, the owners should always be required to carry HO6 policies. Many owners don't understand. They think if the association has insurance, that's going to cover everything. And it does not. And we had a surprisingly large number of people who lost properties in some of the Sonoma County fires, particularly the 2017 Tubbs fire, who turned around to their association and said, well, pay for all my personal property, pay for my cars, pay for everything that was lost, because in that fire, absolutely everything was lost if your home went up. And they were shocked to find out the association's policy doesn't cover any of that. So if your CC&Rs do not already require owners to carry what's commonly called the HO6 policies, they should be amended to require that. You can also make owners responsible for the deductibles. And that helps with all of the smaller little claims out there, all of those toilet line leaks and plumbing breaks and various items like that. Keeps the association from having to pay out all kinds of extra little amounts, 10,000 here, 5,000 there. To go hand in hand with that, associations should review their provisions on who's responsible for reconstruction in the event of damages or loss. And particularly in plan developments, there are good reasons to make the owner responsible for doing the reconstruction and the association responsible for providing that owner with any insurance funds. A lot of old documents will make the association responsible for coming in and doing all the repairs. And even if only one home is damaged, it makes the association responsible for doing special assessments to pay for any costs over and above the insurance proceeds. This, of course, doesn't go over well with the other owners who are now asked to pay up because one person had a kitchen fire. It also tends to, we end up with a lot of people, I should say, who think this is the opportunity to get a complete remodel of their home done off of their neighbor's dime. You can also change to a walls out policy, where all of those little claims for those toilet leaks and kitchen fires and all of that are going to be on the owner and the owner's HO6 policy. And the association's only going to become responsible for reconstructing the home when it is the structure and the walls out that are damaged. Another option is to change to owners insuring their own property. And I'll cover more on that in a second. You can increase the deductible. That's going to reduce your costs. One important thing is to keep up on your maintenance and repair. And I have seen some associations lately that have been able to go back to their insurers and show that they have replaced the roof in a timely manner, that the paint has been done regularly and inspected, and that the balconies have been inspected. And once the insurers see that there are risk mitigations the associations have done, a couple of them have been willing to lessen the amount of increase, or in the case of a non-renewal, to go ahead and take the association back. So it's really vital to keep up on the maintenance and repairs. Next slide. So in the case of high fire zones, we have a number of associations that are getting non-renewals. The insurers are just saying, your risk is too high. We're done with you. We're not going to cover. This has resulted in some of the associations having to go out to the secondary market. And the increases in their premiums have been anywhere from 10 to 12 times what their prior premiums were. It is a humongous increase. There have been a couple of companies that have stepped up and replaced some of the insurers that are pulling out. But even some of those players are denying some that are in higher risk areas. So what do you do in that case? We've been doing a lot of amendments to CC&Rs, which either say, all right, owners, you're responsible for insuring your property. And we have found that in a lot of situations, it is far cheaper for each individual owner to insure their home in a planned development than for the association to insure it. The other item is that individual homeowners can get California Fair Plan and other types of coverage like that, which are not available in commercial policies, so the association can't get them. Now, I have a lot of associations that still want the association to carry the master policy. So we have crafted amendments that have provided that the association still carries the master policy. But in the event the board determines that the premium increase is too high, or they just can't get coverage, the board can shift that responsibility over to the owners. And we include a provision in there that allows the owners to override the board by approving a special assessment and a regular assessment increase. So that prevents the situation where you just may have a board who doesn't like the increase when it is actually bearable for the members. So it's a good way to have a compromise, allow the board to shift the responsibility so that they can respond a lot quicker than going through an election process. But at the same time, give the members an override of that. Condominiums, of course, are a little more difficult because the association owns that exterior structure and needs to insure it. There, they can still do the walls out policies. They can still require the owner to have their HO6, but they're going to be a little more stuck when it comes to options for dealing with the premium increases when they're getting non-renewed for fire insurance. So that's kind of where we're at. I do recommend the associations do a careful review of your insurance provisions. If your documents are more than 10 years old, they are probably not adequate anymore, given all the changes in the insurance market. I think most associations should also do a careful review of their provisions on damage and destruction and restoration. A lot of lessons have been learned since 2017 on how a lot of the older documents provisions don't actually work when reality hits. They have a lot of stuff about when this percentage happens and the coverage is that percentage. And at the end of the day, when people have lost their homes and your board members are scattered and your homeowners are scattered, they didn't work well. So I think those are two areas that associations should pay attention to and get those revised. I want to make one last point for those who are in high fire areas. You do now have public resource codes that apply and require you to perform various fire safety measures around your buildings, such as if you maintain the buildings, you have to put in a 5-foot ember resistant zone. You have to trim up plants and trees 30 feet out. You have to clear brush 100 feet out. But the real kicker that's catching a lot of associations is you have to clean gutters and roofs at the beginning of fire season and periodically throughout. So a lot of my clients previously budgeted to clean gutters once a year, usually right at the end of October, beginning of November. That's no longer adequate in the fire zone. And that may not be adequate even outside of fire zones because of the way we're getting larger storms earlier and at unexpected times, such as last October when there were a lot of insurance claims put in because of the atmospheric river that blew through Marin and Sonoma County prior to anybody having done their gutter cleaning, which resulted in a lot of leaks and water claims. So that's all I've got.
Thank you, Barbara. Thank you very much.
You're welcome.
And so for those of you who've been paying attention, you see that the cost of maintaining a condominium in a homeowner association in California keeps going up. Inflation keeps going up. Insurance costs keep going up. Jury awards keep going up. But if you dare raise assessments to pay for all this, you've got to be a licensed debt collector and all kinds of restrictions to collect that money to pay for those assessments. Don't you love California? I'd like to address my last slide, particularly for the attorneys. These are reports of decisions from the state bar court on attorney discipline. I just picked two at random. The first one involves a criminal conviction for felony assault. An attorney suffered a criminal conviction for felony assault. What happened? The attorney got in an argument at a senior citizen mobile home park about garbage. Items discarded for bulk waste pickup. Apparently somebody wanted some of the pickup and somebody didn't want it, and let them have it. Because of the criminal conviction, the attorney is suspended for 1 year. A fight about bulk waste pickup. The other case, this is for the attorneys, state bar court. The other case, pettit larceny in Virginia. That's the other coast. But if you, shoplifting in Virginia, the attorney pleads guilty to shoplifting in Virginia, $500. Plus, the attorney failed to self-report the conviction. You have to self-report to the state bar. Probation for 1 year. What these two state bar court opinions tell you is if you're an attorney and have any involvement with law enforcement involving $500 shoplifting in Virginia, any involvement with law enforcement, you're going to be in trouble. That's our presentation for the past 4 months. I hope you have enjoyed it. I had fun. Thank you.
Hello, Mark, and I want to tell you thank you so much for this as well. We will be moving into the question and answer portion of today's program. A short reminder for you to vote for your favorite questions, 2 or 3, by using the thumbs up icon in the Q&A or question and answer feature at the bottom of your screen. This will help us to prioritize the questions. Thank you so much for coming and doing this. So we'll go ahead and start with that. I'll give you a couple, maybe a minute to do your thumbs up voting, and we'll take the first one here in just a second. I'll pull it up.
I have one question from chat for Kevin. Kevin, would you be able to repeat that electrical panel information about the associations? You're muted, Kevin.
Unmute, Kevin.
Okay, sorry about that. So they're called Zinsco panels, Z-I-N-S-C-O, Zinsco electrical panels. I did some research myself last week about them because so many carriers now are really concerned about them, and they have apparently have failed national safety standards for safety. The big problem with them is when there's electrical surge, the trip isn't working properly, and that has led to fires. So the insurance companies are taking their data from the experts in the industry that are telling them, hey, watch out for Zinsco panels. And it's not something new. It's been around for a long time, but it seems like the insurance companies are paying more attention to it today. So I do recommend put it in your reserve study, start to replace those panels, because don't be surprised 1 year if your insurance company says you have to replace them, or if you don't, we're going to non-renew.
Okay, thank you. Thank you so much, Kevin. So the #1 vote getter here is from a question posed by Marianne Monk. Wasn't there recently a decision that assessments are not considered debts, not subject to the Rosenthal or to debt collectors? Do you have an answer for that, Mark, or anyone of our attorneys?
I would defer to Tom
Tom? Okay.
here.
Yeah, okay, so I just checked the cases earlier this morning to make sure that I was, saying the right thing. And if there's something I've missed, maybe you can contact me outside of this issue. But basically, there are some circuits in the federal court system that have said that HOA assessments are subject completely to the Fair Debt Collection Practices Act. The good thing is, this is not in the Ninth Circuit in that covers California. So, but it's out there, and I would not be surprised at some point in the future that HOA assessments, not with debt collectors, okay, but just the original HOA would be subject to it. The reason why it isn't, according to, basically California law and thinking, is that the Fair Debt Collection Practices Act does not cover original debtors. So the original debt is with the HOA. Okay, it's not with a third party like a collection agency. They would be subject to it. And then you get into another question about, is this a debt? Is it credit? What is it? Okay, anyway, I wouldn't worry about it at this point for California, but attorneys, by and large, the answer is no. If the majority of your practice, not even the majority, if it's 4% or more that you deal with collection, you're subject to it. If it's less than that, so far you're okay. I hope that answered it.
Okay. Thank you very much, Tom. That I think did answer it. I appreciate it. Now, Kay Dyack asks, we're trying to restate our governing documents with a restriction on 10 breeds. I assume these are breeds of dogs. Owners are up in arms voting against the document. We've explained this is a liability issue. They say it's the owner's responsibility and not the HOA's. How do you counter this comment?
That's a good question.
As I understand the question, is whether the HOA should restrict certain breeds of dogs.
Yeah.
Ask yourself, is this a problem? Are there other ways to address the issue? If it's waste, pet waste, are there other measures to take to solve the problem of pet waste besides restricting breeds? The problem with restricting breeds is if a breed is allowed to exist, even if you don't know it, even if you need a blood test to establish this is the breed. If you allow the breed and you're supposed to reject the breed, pull out the checkbook. Look for other ways to accomplish your goals.
Mark, if I can add to that,
Please do.
there were a couple of cities that several years ago, when pit bull incidents were a big thing, that tried to have city ordinances that prohibited or limited certain breeds. And those were actually struck down in the trial courts because there wasn't sufficient evidence to show that just because a dog is of a certain breed, it is necessarily vicious or dangerous. So I think the better way to approach that, because I think that CC&Rs would probably fall on that same challenge if someone took you to court, the better way to do that is to have a provision that prohibits any dog that is vicious, that is known, that somebody knows is a problem or a danger, and give the board a right to after notice and hearing, cause that dog to be removed from your community. Now, you've taken a reasonable step to keep safety in your community because you've prohibited vicious and dangerous dogs. And you're not going to run afoul of the breed restrictions and the whole question of whether a dog is necessarily dangerous just because it's of a certain breed. So that's the way I approach it with my clients.
Point is that whatever the restriction, enforce it.
Enforce it.
If you have a restriction and you don't enforce it, and then somebody gets hurt, pull out the checkbook.
Okay. All right, thank you. Thank you, Barbara. Associations rely on member dues to continue operations and fund maintenance work. When numbers default on these payments, these payments are the assessments, the HOA could face financial crisis. The Fair Debt Collection Practices Act does not consider homeowners associations as debt collectors. As such, the FDCPA does not apply to HOAs collecting their own unpaid dues or debts. So the question, does California consider HOAs as debt collectors? I think that may have been touched on, but Tom, maybe you can.
Yeah, I think I did touch on that a little bit earlier. California does not consider HOA subject to the Fair Debt Collection Practices Act.
Okay.
Other states do, but California does not.
What about feds?
No, the federal does not in our circuit, okay? Ninth Circuit does not. There are other circuits where they do consider homeowner assessments subject to the FDCPA, Fair Debt Collection Practices Act, but not California.
Okay, and so here's one from Terry Sweet. Can you please elaborate on the relationship between mandatory reserve collections and property values? Thank you.
All I pointed out was reported in an article about Florida. Florida changed the rules so that if you qualify as over 25 years old by the beach or over 30 years old inland, you've got to mandatory collect reserves. And how do you do that? You issue assessments based on the repair costs of the project. They can, after 25 years, they can be huge. When per unit assessments are increased dramatically to meet the law requiring collecting reserves, property values are going to fall.
Anybody else want to jump on that? Yeah. Obviously, the collection of reserves is related to the repair, maintenance, and replacement of a common asset. And there's no antiques really in these buildings, and things just get worse. And so the property values will diminish if you don't maintain, repair, or replace your assets. So that's really the connection, and you end up losing property value.
At the end, you're going to have condo termination.
Exactly. One of the clearest and cleanest ways to take care of a situation like that is to sell the condo.
So, the value of properties is, primarily driven by location. For example, my daughter is attending Cal grad school. I was over there Saturday. We looked at some of these buildings that the landlords have had since 1930s. They're in terrible condition, but they still want $2,000 a month. But in our association, we're really good about making sure the reserves are being added all the time. And I think that is a real strong way to keep your property values up, which I think was part of the original question.
Okay, so here's a good, more contemporary, kind of a contemporary issue from our anonymous attendee, or the AA here. HOA wants to install an electric charging station or stations in our maintenance yard. Do you see liability with that?
That involves all kinds of problems and questions.
Yeah.
I had an association who wanted to install charging stations. I suggested they bring in an expert electrician who found aluminum wiring
Oops.
would not support a charging station. It's more complicated than just, should we put in a charging station? You've got to make sure your association has the wiring and the setup of, so it can be done. You've got to inspect about whether sufficient parking space can be taken for the charging station. A lot of issues. It's not just, do we install a charging station or not?
I would think a lot of the homeowners that don't have electrical cars would object also to the association spending money for those few homeowners that do have electrical cars. And it would be the electrical car owners who would have to pay for all that too.
There's,
Yes,
there's, Go
If
ahead.
your charging stations don't have a way for that individual using it to pay for that electricity, you will end up with litigation possibly, or at least a very expensive dispute with the majority of owners who don't have electric cars. I've seen that happen with an association up in the North Bay area.
Mhm. I've seen that happen too, and it's an equity situation with regard to that. The board did vote in the case I'm thinking of. They voted to put the EV in there, and I got a call from somebody who's on fixed income and says, I'm not changing my car, and why should I pay for this? And that's what it ends up. So you have an equity liability, if you will, if you do something like that. But you also have what Mark was alluding to, the risk of fire and other catastrophic failures in the systems themselves. There was a time, and I don't know if they fixed this, I assume they have, back many years ago when the batteries used to explode, and for solar and the EV process there. So you really need to be very, very careful about that, and get the pros in there. That's how you protect yourself, is make sure you have experts helping you out. There is a 5% supplement on our HOA bill. There is no record of a board meeting and no response for a request of minutes of a board meeting where this was discussed. There is a claim that this was mailed May 31st, but no board meeting prior to this. There is no response at all from the management. What do you do? I mean, can they do that? Can they just increase 5% and not let anybody know until they get the bill? Anyone want to take that?
Let me give a shot at this. It depends on when that's done. I mean, the board can increase up to 20%. Obviously, there should be a budget that goes out, which is required by the civil code. So I would be a little bit suspicious. I mean, I don't have an answer offhand, but obviously they need to say, at least from a transparency standpoint, they need to tell them why the increase. Okay, costs have gone up. Insurance, landscaping, gardening, whatever, water, PG&E or whatever.
Okay. Yeah, there's a lot of issues packed into that question. So I think we're a little over. Connor, how are we doing on time here? We're
about 10 minutes over.
So I think, and I want to say thanks to everybody for hanging around for this, but we'll take one last one, and then what I'll do is we'll move into the final announcements. From Terry, is there a statute of limitation for discovery and remedy of assessment liens that were improperly recorded? And that sounds like Tom, right?
Yeah, there is. It depends on, your basic statute of limitations. And by the way, if you get a delinquent homeowner and they're really going to fight it and then they go to an attorney, one of the first things is going to be the statute of limitations. It's a little bit dicey as to what exactly it is, but just a rough rule of thumb, 4 years for a debt, okay? If it's a violation of the CC&Rs, it's 5 years. So it depends on when the debt was incurred, okay? The difficulty with homeowner assessments, let's say in January, it's $100, February, it's $100, March, it's $100. So your statute of limitations is constantly moving according to when the debt was incurred. I don't know if that answers the question, but it's not a real simple answer.
I think the simple answer is what Mark said earlier. If you're collecting debts, talk to your attorney and get them involved or another suitable professional. That's the right answer on that one. And then you can figure this out. So I want to say thank you to everyone for staying around. I apologize for those questions that we weren't able to get to today. And I want to say thank you to for all of you that are ECHO members for being ECHO members. But if you're not a member, we'd love to have you join the club and be part of the ECHO family. This year, ECHO has planned more than 60 online events. In addition, we have a vast array of resources for HOA boards and homeowners, including personalized guidance and challenging issues and a series of educational programs. I get calls and I help people. That's what that personalized guidance is all about. So you can join ECHO by going to our website at www.echo-ca.org and clicking on the membership tab. For those of you who are interested in meeting in person, we have started our regional resource panels. The next panel meeting will be the North Bay Resource Panel in Novato on July 13th, which will focus on water conservation and fire prevention. Hot topics today. And we will be, so that's 2 days from now, or tomorrow actually. So we are, and I'll be there. I'll look forward to seeing you. We are excited to invite any HOA board members or former board members to join the ECHO HOA Board Members Club. This exclusive group meets every second Tuesday of the month from 5:30 to 7 p.m. and features a unique opportunity to learn from your peers. Please consider joining the club, and we have about 240 members sharing information and knowledge. The next board meeting is actually this evening at 5 o'clock, 5:30 to 7 rather. And we look forward to seeing any board members there who would like to participate. If interested, please click on the sign-up sheet in the packet or email Patty Curzet at pkurzet@echo-ca.org. Well, this has been a fun program and very interesting. Thank you, Mark. As usual, it's been a lot of fun and very interesting and informative. And of course, I want to say thank you to all of our attendees for participating in today's webinar. ECHO appreciates your investment in education to build better HOA communities.